next week. But let me just say that that amount of disclosure in that note is not actually for the cost of, it's not the cost of legal fees. It's actually legal claims against the SABC. So it's a provision for legal claims. And what that means, essentially, it's an accounting term that refers to a liability of an uncertain amount or timing. So what happens is that the SABC could be sued by anybody for whatever reason, and we're saying that when we compile all the cases that the SABC is exposed to, then the lawyers will tell us that if everything went against us as the SABC, the potential liability is prior year, which was 14-15, was 171 million, and they're saying it's this year their estimate of the same liability is 250 million. So it's not the cost of paying lawyers, it is the potential cost that the SABC will be exposed to through if litigants claim against the SABC. So I think that one needs to be corrected. It's not the price, or rather the cost of paying lawyers. I just need to put that to rest. Then the second other matter that I want to talk about, I know we're going to have a detailed report on the annual financial statements, is I think Dr. Mulder talked about 53% of employees resigning. That's not true. What it is in the annual report, 199 employees left the organization in that financial year. Of those, 53% resigned. Now the question is, why? We came here and said that we had a situation where there was medical aid fraud at the SABC, for which 123 people were implicated. Some of them chose to resign. So it's not correct that 53% of the total population resigned, because I can tell you in 14-15, we had 3,875 employees at the SABC. This year we have 3,835. So there's no possibility that half could have resigned. Let's just put that to rest. The other issue that I want to talk about is around the King 3 responsibilities. My former mayor of Ekurhuleni, now honorable, talked about King 3. You're right, King 3 it's imperative that we comply with King 3. But there are a couple of issues in this scenario that we are faced with. The first one is the public protector issues a report that has a series of findings. And we as the SABC then go to court, and remember at that time we were not sure whether this report was binding. So the Constitutional Court says, yes, it's binding. But it says that after the fact. Despite that, we looked at the findings and said, the findings are affecting an employee of the SABC. Employee who was deployed currently that time as the COO of the organization. So we said, if you are the COO, here is a report that has found you wanting. So what did he do? He stepped down from the position for about a week, or I think it was 2 to 3 weeks, to face a disciplinary session. The disciplinary session at the SABC or process works as follows. If there is a charge, you get the Employment Relations Group, which we call ER Group, to press charges. Now, because of the nature of the event, it was a very serious case involving somebody who was very prominent. We said, we don't want this to be contaminated. Let's look for an independent prosecutor or initiator in this word. In this case, let's look for an independent chairman. And we got an advocate to chair the process, and we got some other person to prosecute. To make sure that it's independent, we did that. That's at one level. Second other level, we said that you will also make it public, such that the public can see what is happening. We went through the process, and remember that The report is not being contested here. The SABC is not contesting the report. The report is there. We say that now that you are found wanting with this report, it becomes an employer-employee issue. And we appointed an independent advocate who took the organization through the process of disciplining Mr. Motsoeneng. He comes out with findings and says, not guilty. But in the process of the disciplinary, certain witnesses were called in to testify. And we found that there were disparities between what was in the report and what was ventilated at that disciplinary. And that's what triggered a review of the public protector report. So we have taken it to court for review. It's not saying that we disrespect the report. We're saying, as part of ventilating the charges against him, certain people denied, for example, being interviewed, and we said, all right, we will take the report for review. However, the conclusion of that disciplinary was that he's found not guilty. I sit here now as the GCO with a disciplinary, transparent. You may want to call it a farce, but that's another matter. If you want to call it a farce, and you have said that you have taken it to court, so that is a court matter. But before me is a report from an independent chairperson saying that he's not guilty. What do? Immediately I consult my legal team and ask them, in light of the SCA judgment setting aside his appointment as COO, what is the status? They say, you cannot face a disciplinary if you're not an employee, first of all. So that is settled, in fact, that he's an employee. The case was not about whether he's an employee or not. It was about the process elevating him to COO, which has been set aside. So the legal opinion I get is that you put him back in his old shoes. We look for his old shoes. It was an executive director, a group executive, corporate affairs, which was stakeholder relations. So we, as we have said here, looked around and said, as an organization, where is the best place to put Mr. Motsoeneng? No one in court or any public forum has said that as group executive stakeholder, which is now corporate affairs, is incapable of doing that job. So it only came to reason that we put him back where he belongs. The incumbent there is Bessie Tugwana, capable broadcaster, and we have projects, a couple of projects that we are running at the SABC, many of which include, the list includes the following. We have the DTT project. We have the project to introduce local content, specifically on SABC 3. We have the issue about new businesses, because we are looking at our revenue streams, and we're seeing the traditional revenue streams of advertising and TV licenses have reached the peak. So we're looking for new businesses. Of course, we can't share that with you here because it's information that is of commercial sensitivity. We have a project to look at the alignment of the organization, SABC as an organization, because as a result of the findings of the Auditor General, many of them were because the organization had grown and systems had mutated in such a way that we had silos. So we are reorganizing it. That's why you'll see name changes happening. Stakeholder and provinces is now corporate affairs because we found there was a misalignment between stakeholder and provinces and marketing. They walked in different directions, yet they were doing the same thing. So there are these projects that we are implementing. Another one is the transformation specifically around supply chain management in the areas of information technology and technology supply. These areas have not been they are not properly representing previously disadvantaged people. So those are things we have put in projects. We said, Ma'am Bessie then can move to that project office because the board approved a project management office in the GCO's office. So she was placed there. So in short, I, as acting GCO, was in a quandary. There's an employee-employee matter at hand that arises from a public protector report. The employee is taken through a disciplinary, and the employee is found not to be guilty. What should I do? The only reasonable thing at that time was to put him back in his old shoes. And my legal team gave me that advice. The issue is about...
You say the only thing you could do?
Only legal. Legal gave me an opinion that legally you cannot put him in any worse position than he was previously. The set aside from COO meant that he gets away from the COO position, but he's still an employee. So put him back in his old shoes. So we look at it as a business and say, what is the best place he can be? And remember, no one, whether it's a court or even the board, has found him incapable of doing his his job as GE Corporate Affairs, what was previously his role of stakeholder, with an addition of marketing. So it's in this light that we say that this was the best decision that we could take. Somebody has asked, what is his salary and what? I'm a bit sensitive in this area because that's also in an employee area. Suffice it to say that if you look at the annual report, which will be ventilated next week, his salary is reported there as an executive director. But the negotiations after the set aside is something that I would be very coy in talking about, because remember it's a sensitive issue between employer and employee. Thank you very much.
Yeah, they are still responding, Honorable Shafam. Doctor?
Thanks, Chair. The question on DC charges, disciplinary hearing charges. The charges we followed, because the question was we drafted the charges, how did we do that, and we followed what? All the charges we followed for that or prescribed to the DC committee were listed by the judge. So we gave them that as a brief, that the judge wants you to look on 1, 2, 3. We didn't draft ours. Everything was from the judge. Then the issue of asking for the report from the disciplinary hearing. Yes, we'll submit that to this committee. On our side, we have put that report online. So since we finished the DC, we published the report online. So it's already there for public consumption. The Chairperson, I think I have to emphasize that we, as the board, are appointed by this committee. And through our shareholder, who's the Ministry of Communication, we account to this committee. And we report to this committee. There was a question of meetings for the board, and do we correlate and what? If you check on our annual report, and maybe the company secretary has the figures, from all odds, we have met all meetings that any normal or formal board will have met. There's no non-compliance of meeting our committee meetings. That's board meetings and committee meetings. And I want to emphasize that, honorable members, when we came in as the board, we were given task to turn around the SABC. We were given a task to pay for the loan that this committee granted us through Nedbank. And any board in any company or any institution that is in crisis, Chairperson, will not meet the minimum compliance of governance. I understand the Honorable Member was mentioning the company law and King 3. And this is what, through our company secretary, in each and every meeting, we're reminded for. And we stress this and emphasize to our executives to flow this down, the compliance. That is why even today, if you call the Auditor General tomorrow, which when we arrive as this board, the SABC was not audited by the Auditor General. It was an independent company. We are the ones, this board, that brought in the Auditor General, because this is the auditing voice of South Africa. If you call them tomorrow, Chairperson and Honorable Member, they will tell you about the adherence to the compliance of this board to run the SABC. Now, if a board is told about crisis, first thing that comes to your mind is governance. And that will reflect on your reportings. Do we submit the quarterly reports, Chairperson and Honorable Members? Yes, we do. And in all, each and every quarterly reports, that's where your governance, your overseeing, your financials will be reflected. So as you mentioned, Chairperson, that maybe some of these issues will need to be categorized so that we come and clear them one by one or by groups. Because maybe when we submit a report, there's no enough time for honorable members to go through it as a report. So we did the first two mandates that we were given to pay off the loan and to turn around the corporation as this board. If there's an issue of implementing the public protector's recommendations, I remember when we arrived, I think it was 3-4 months down the line as a new board, we were thrown with this report. And we can't sit here and say it doesn't belong to us. It belonged to us. That's why we drafted the implementation plan and sent to the public protector in 2014 to say, public protector, this is how we're going to implement the report. And the public protector gave us the response that I have received your implementation plan. And all these, Chairperson, we report them on our quarterly reports when we bring our quarterly reports here, that we have drafted the implementation plan. Now, where we got stuck with the public protector's report, Chairperson, is the highlight that we received during the disciplinary hearing as instructed by the court. Remember, the disciplinary hearing is from a recommendation of the public protector's report. I understand that some of the members were saying we formulated the DC or we came up with the DC. It's part of the implementation to the public protector's report. Then we got instruction from the court, from the judge, to say, I want you to conduct the disciplinary hearing as recommended. That is why we were even mentioned on the Constitutional Court when the chief judge was giving the verdict about Nkandla, that the SABC implemented the recommendation of the public protector by conducting the disciplinary hearing. We were mentioned there. So I don't understand if members have ideas of we don't want to follow the public protector's report. Then we followed that. We said to the independent panel, we don't have to formulate. Remember, we're contradicted in this issue. The judge has stipulated, we said as the board, do we agree that as is from the judge, these are the charges. We're going to give the brief to the disciplinary hearing. And it was done. Now, the highlights came during that process, Chairperson, that from the 14 witnesses, almost the top 4 or 5 of them, if I'm not mistaken, they said when the investigators of the disciplinary hearing, calling them to say, look, this is per instruction on the recommend, this is the report, come and witness. They said they've never met any investigator from the public protector. They have never been consulted. One of them gave us an affidavit, Chairperson, which is here, that no, you're calling me for the wrong things. I, in fact, went to the public protector to complain about the acting CEO, Mr. Nicholson. Here is my complaint, not to Mr. Motsoeneng. So I'm implicated on the wrong report. So that's where we started to be puzzled to say, what is happening here? Because from the 14 witnesses, I think we received 4 or 5. That is why now when the report came of the disciplinary hearing and cleared Mr. Motsoeneng, we said as a board, now we're sitting with a problem here. We seek for legal advice. So this is showing you and this House, Chairperson, that how compliant we were following our steps. We didn't sit as a board and said, yeah, which step do we go? Let's take this to review and what? We ask for the legal advice. And now, whether the legal company, Chairperson, or the legal team that were appointed is whose firm or what, but we seek for the legal advice. That is why we took this to review. On top of that, Chairperson, we're still following, even though this is on review. That is why now when this appeal set down the position, appointment of Mr. Motsoeneng to the COO, we followed it. We told him to step down. Now, the legal minds will tell you, Chairperson and honorable members, that when the judge ruled or the court ruled to step down the appointment because of irregular procedures or whatever mentioned there, the court or the judge is not stepping down today. It's not stepping down when the court or the judge was announcing at that date. It's stepping down the appointment. So which means the first day while you were appointing that person. So now that's where you looked at the labor relations. Who was that person when the judge stepped the appointment of the COO? That person was the employee of the SABC. That's when now, as the board, we said, executives, this is your person. From what, as the board, according to Broadcasting Act, the board recommends to the minister the 3 executives, the COO, the CFO, and the CEO. Then we said, from our side, where we recommended the appointment of the COO, where we were in charge of this level of the Broadcasting Act, the court is saying we have followed irregular procedures. We're stepping this employee. Had it happened that Chairperson, Mr. Motsoeneng, was an outsider, we were going to consult Mr. Motsoeneng and said, our employees. Now, as the employer and the employee relationship, where we employed you as the board, the court is saying it was irregular. Then and sort it from there. But now the position here of setting down the legal readings and interpretation is that this person, as the employee of the SABC, where you board took over and appoint him to the COO, I'm setting that as irregular. So that is why we handed it to the executives to say, he's your employee. And that's what the acting GCO was trying to explain, to say he looked for the legal advice, to say now I am faced with Labor Relations Act. And now Labor Relations Act, internally, I will assume, as the CEO myself, the previous CEO, I will consult my HR, my ER, if I have that, or labor relations, first before I even get a legal mind from outside or advice from outside. So I think that's what the acting CEO was trying to say, Chairperson. So all of the other questions that is the board fit? I think from where I'm standing, Chairperson, when you want to analyze and assess the fitness of the board, you analyze it and assess it from compliance. Because compliance will give you the company law, will give you King 3 code, will give you PFMA, and all related acts and legislations. That's where you'll analyze the fitness of the board. Yes, you're right, Honorable Chairperson. The fitness of the board is not analyzed or assessed through individual ideas. It's analyzed through governance, as we have mentioned, as other honorable members were mentioning there, and compliance. So once you don't see any light of compliance to the institution, which is this authority, this house, that's when you start to trigger problem, that this board has a problem. So, Chairperson, I think from my side, those are the few I try to highlight and answer. Thank you.